Some cases don't begin with conflict. They begin with an ultimatum. She didn't come to me angry. She came to me exhausted. Exhausted from pretending that love and motherhood could coexist under the same roof when every day proved otherwise. I'm attorney Claire Morgan. I've handled custody disputes, divorce cases, and family conflicts for years. But this case stayed with me because it centered around a question no parent should ever have to answer. Who do you give up, your child or your marriage? If you believe real stories deserve to be told honestly, stay with me until the end. Because what looks like a family disagreement on paper was, in reality, a slow and devastating emotional trap. When she first told her story, she started with something simple. She said her marriage wasn't always cruel, it was just conditional. Before the child was born, there were rules, subtle ones. Expectations about how she should speak, how she should behave, how much space she was allowed to take up in the relationship. But after the baby arrived, everything changed. Not suddenly, gradually. Her husband didn't resent the child openly. He didn't shout or threaten. Instead, he withdrew. Attention became scarce. Affection became transactional. Support came with conditions. If she prioritized the child, she was accused of neglecting her marriage. If she tried to balance both, she was told she was failing at each. There was no winning. What troubled me most was how often she blamed herself while telling the story. She questioned her instincts as a mother. She questioned her right to protect her child emotionally. She questioned whether choosing her child made her a bad wife. That kind of doubt doesn't come from conflict, it comes from pressure. Her husband framed his dissatisfaction as concern. He said the child was becoming too attached, that boundaries were being crossed, that she was losing herself in motherhood, but what he was really losing was control. The more she focused on her child's well-being, the less she adjusted herself to accommodate his comfort. And that imbalance did not sit well with him. Arguments followed, not about love, but about loyalty. He wanted reassurance that he still came first. She wanted reassurance that her child was safe emotionally and psychologically. Those priorities were not equal in his eyes, and slowly the pressure escalated. Comments became comparisons, silence became punishment, withdrawal became leverage, until one day the ultimatum was spoken out loud, not shouted, not threatened, delivered calmly as if it were reasonable. Choose her child's emotional needs or her marriage. That was the moment she realized this was no longer about compromise, it was about surrender, and she refused. What followed was not immediate separation. It was something more damaging. A battle of endurance. One where every decision she made as a mother was reframed as rebellion, and every act of protection was labeled defiance. By the time she walked into my office, she wasn't asking how to save her marriage. She was asking how to protect her child without losing herself entirely. And that question changed everything. Ultimatums rarely arrive without preparation. By the time he asked her to choose between her child and her marriage, the ground beneath her had already been softened. This was not a sudden demand, it was the final step in a process that had been unfolding quietly for months. After the child was born, her husband began speaking a different language. Not cruel, not aggressive, concerned. He questioned routines, criticized her instincts gently, suggested that too much attention was unhealthy. At first, she listened. She adjusted feeding schedules, changed sleeping arrangements, tried to be more present as a wife. But the goalposts kept moving. No matter what she changed, it was never enough. If the child cried, it was because she was spoiling them. If the child clung to her, it was because she wasn't encouraging independence. If the child struggled emotionally, it was because she was too attached. Motherhood in his framing became a flaw, and the more she tried to correct it, the more he emphasized its failure. This is how emotional blackmail works. It doesn't demand sacrifice immediately. It convinces you that your natural instincts are dangerous. He began keeping score, how many hours she spent with the child, how little energy she had left for him, how her priorities had shifted. Love, he implied, required balance. But balance, in his definition, always favored him. Any boundary she set was framed as neglect. Any protection she offered her child was framed as overreaction. Any resistance was framed as disrespect. Over time, tension replaced intimacy. Silence replaced discussion. When she attempted to talk about how unsupported she felt, he redirected the conversation. He spoke about how lonely he was, how invisible he felt, how the child had taken over the relationship, and slowly, subtly, responsibility shifted. She was no longer just a mother, she was the cause. This pressure intensified behind closed doors. He would withdraw affection for days, avoid conversations, refuse to engage. Then when she tried to fix it, he would say she was proving his point, that she was too emotional, too reactive, too invested in motherhood to see reason. She began questioning herself, not as a wife, but as a parent. That is the most dangerous stage, when a mother begins doubting whether protecting her child is selfish. She sought advice from others. Some told her marriage required compromise, others told her children adapt. Very few recognized the imbalance, because from the outside his demands sounded reasonable. Don't you think you're focusing too much on the child? Don't you think your marriage matters too? Don't you think there should be boundaries? What no one asked was this: why did protecting her child feel like betrayal to him? The ultimatum itself came quietly. There was no argument that day, no raised voices. He simply told her he could not live in a marriage where he felt second. He said things couldn't continue this way, that something had to change. And then he said it, she needed to decide what mattered more, her child's emotional dependency or her marriage. He presented it as logic, as fairness, as necessity, but ultimatums are not negotiations, they are declarations of power. She did not respond immediately, not because she was considering it, but because she was stunned. Because no one prepares you for the moment your partner asks you to choose against your child. In the days that followed, pressure increased. He spoke less, watched more, commented on her decisions with quiet judgment. He told her she was ruining the family dynamic, that the child would grow up dependent, that she was teaching weakness. Each comment carried implication. If she didn't change, she would be responsible for what came next. This is how control disguises itself as consequence. She began documenting conversations not out of suspicion but confusion. She needed to understand how love had turned into leverage. She noticed patterns, the way his concerns surfaced only when he felt ignored, the way compromise always required her sacrifice, the way her child's needs were framed as obstacles. By the time separation was suggested, not yet spoken openly but implied, she was no longer emotionally reactive. She was alert, and that shift unsettled him. Because compliance had been replaced with clarity, she came to me shortly after, not to file immediately, not to accuse, but to ask a question I hear too often from parents in her position. How do I protect my child without being punished for it? That question told me everything. This was not a marriage struggling with adjustment. It was a dynamic struggling with loss of control. And the law, when it becomes involved, does not ask who feels replaced. When ultimatums fail, pressure changes form. After she refused to choose her marriage over her child, her husband did not escalate emotionally. He escalated strategically. The home did not become louder, it became quieter. Conversation narrowed. Affection disappeared. Decisions were no longer shared. Instead, everything revolved around observation. He watched how she parented, commented on routines, questioned her choices not openly but persistently. Every decision she made for her child became something that could be challenged later. That was not accidental. This is the stage where many controlling partners begin laying groundwork, not for reconciliation but for leverage. He began mentioning separation casually, not as a threat, as a possibility. He spoke about what would happen if things didn't improve, about how courts evaluate parents, about how children need structure, not emotion. These comments were never delivered during arguments. They were delivered calmly. As information, this matters, because information, when framed selectively, becomes intimidation. She began feeling watched in her own home, not physically. Psychologically, she wondered how every choice might look if repeated in front of someone else. She second-guessed comfort, affection, protection. This is how fear enters parenting, not fear of harm, fear of judgment. He suggested counseling. Not for the marriage, for her. He implied she was too attached, too anxious, too reactive. That suggestion carried weight, because once mental stability is questioned, custody becomes vulnerable. She declined, quietly, without confrontation. And that refusal shifted the dynamic again. He became distant, unavailable, emotionally absent but increasingly present in decision-making. He asked more questions about schedules, about childcare arrangements, about time allocation. On the surface, it looked responsible. In reality, it was preparatory. By this point, she had begun documenting more deliberately, not because she intended to file anything, but because something felt wrong. She noticed how often conversations turned toward how courts usually see things, how frequently he referenced what was reasonable, how often her emotional responses were framed as evidence of instability. These were not coincidences, they were positioning. Eventually, the suggestion of separation became direct, not framed as punishment, framed as inevitability. He told her he could not remain in a marriage where he felt secondary, that the dynamic was unhealthy, that the child would suffer if things continued this way. Again, responsibility was placed carefully. If separation happened, it would not be because of his demands. It would be because of her refusal to change. This is the most damaging form of manipulation. When someone makes you feel responsible for outcomes you did not create. The conversation about custody followed soon after. Casually, he spoke about shared arrangements, about fairness, about balance, but he also spoke about concern, about whether she could handle things alone, about whether her emotional investment was healthy. This was the first time she felt real fear, not for herself, for her child. Because custody is not decided by intention, it is decided by perception, and perception can be influenced long before court is involved. She became more cautious, not reactive, cautious. She stopped responding emotionally, stopped defending her instincts verbally, stopped explaining. This change unsettled him because emotional reactions had always been easier to frame. Calm resistance is harder to discredit. That was when the pressure intensified externally. Family members began asking questions, friends expressed concern. Advice began circulating. She was told not to weaponize the child, not to alienate a parent, not to overprotect. Language matters. Because once certain words enter the conversation, they shape outcomes. She realized then that this was no longer just a marital conflict. It was becoming a narrative battle, one where her role as a mother was being subtly reframed. She sought legal advice quietly, not to file, to understand, and what she learned confirmed her fears. Custody cases do not always favor the most caring parent, they favor the most stable-appearing one. That knowledge changed how she moved through the world. She documented routines, kept records, maintained consistency, not because she wanted a fight, but because she could feel one forming. Her husband sensed this shift. And once again, he adapted. He became cooperative, friendly, publicly supportive. He praised her parenting in front of others, presented himself as understanding. This was not reconciliation, it was positioning. The contrast between private pressure and public calm was stark and deliberate. By the time separation became official, the groundwork had been laid, not for compromise, for contest. She came to me shortly after that, not panicked. Focused, she didn't ask how to hurt him, she asked how to protect her child from becoming leverage. That distinction mattered, because this case was no longer about marriage. It was about whether motherhood could exist without permission, and whether choosing a child would be punished. Part 3 complete. When you're ready, say Part 4. Part 4 will move into formal separation, early custody negotiations, manipulation through reasonable demands, and the first legal pressure points. This case is now fully in its legal phase. Start Part 4. All right. Here is Part 4 of the new case, lawyer-narrated, serious, controlled, and deeply emotional. This part moves fully into the legal phase where pressure becomes formal and the child becomes leverage. Case, Part 4, lawyer-narrated, formal separation, custody, leverage, reasonable control. By the time separation became official, the emotional groundwork had already been laid. What followed was not chaos. It was organization. That distinction matters because organized pressure is far more dangerous than emotional outbursts. It is quieter, more convincing, and easier to justify. When formal separation discussions began, her husband presented himself as cooperative. He spoke calmly, used measured language, emphasized fairness. He did not argue against her role as a mother. He questioned the way she fulfilled it. This is how control enters the legal space, not by denying love but by redefining competence. He proposed shared custody early, not aggressively, not unreasonably. On paper it looked balanced. Equal time, structured schedules. clear boundaries, but beneath those proposals were conditions. He questioned nighttime routines, criticized emotional responsiveness, suggested that too much comfort created dependency. Each concern was framed as child-focused. None acknowledged the context that led there. He emphasized stability, but stability as he defined it meant predictability, not safety. It meant schedules over sensitivity, rules over responsiveness, distance over attachment. And slowly his language began shaping the discussion. She noticed how often the word reasonable appeared: reasonable parenting, reasonable boundaries, reasonable expectations. What he was really asking for was compliance. When she resisted certain arrangements, particularly those that disrupted her child's sense of security, the tone shifted. Not outwardly, procedurally. He began documenting her responses, referencing her reluctance, noting emotional reactions. This was no longer about agreement. It was about record. She responded carefully, not defensively. She explained her decisions in child-focused terms, maintained consistency, avoided emotional language. But restraint does not prevent pressure, it often intensifies it. During early negotiations, mediation was suggested. Again, this sounded reasonable. Mediation implies compromise, collaboration, balance. But mediation only works when both parties negotiate in good faith. Here, one party was negotiating for power. During those sessions, he appeared patient. He listened, nodded, acknowledged her concerns, then reframed them. He suggested she was overprotective, that her anxiety shaped decisions, that the child needed exposure to independence even if it caused distress initially. Distress, he argued, was temporary. Dependency, he claimed, was permanent. This framing placed her in a defensive position. If she objected, she appeared emotional. If she agreed, she compromised her child. There was no neutral ground. She began to understand something crucial. This was not a disagreement about parenting styles. It was a dispute about authority. Who decided what was best for the child, and whether her maternal instincts would be treated as insight or liability. The legal paperwork reflected this tension. Subtle language appeared, concerns about emotional regulation, suggestions of enmeshment, questions about judgment, nothing explicit, nothing provable on its own. But collectively, it created an implication, and implications are powerful in custody matters. This is where many parents make mistakes. They react emotionally, they argue morality, they defend intention. She did not. She focused on evidence, routine logs, medical records, school reports, professional observations. She anchored her parenting in consistency rather than explanation. That choice mattered, because consistency withstands scrutiny better than justification. Her husband responded by escalating documentation on his end. Emails, messages, meeting summaries, each written carefully. Each designed to sound collaborative while preserving advantage. The dynamic had fully shifted. This was no longer about reconciliation. It was about positioning for outcome. And the child sat at the center of it, not as a person but as leverage. That realization was devastating, not because she feared losing, but because she recognized the cost. Legal processes demand distance. Children require presence. Balancing the two is one of the hardest challenges a parent can face. She adjusted, not emotionally, strategically. She limited unnecessary communication, requested written correspondence, clarified boundaries. Each step reduced conflict, and each step was noted. Her husband framed this as uncooperative, as cold, as resistant. But cooperation that requires surrender is not cooperation, it is compliance. As preliminary hearings approached, the tension crystallized. Positions hardened, language sharpened, and yet outwardly everything remained calm. That calmness is deceptive, because when control operates quietly, it is harder to challenge and easier to excuse. By the end of this phase, one thing was clear. The question was no longer whether she would choose her child over her marriage. That choice had already been made. The question now was whether the system would punish her for it. They take private decisions and place them under public examination. They turn instinct into evidence and love into something that must be justified. By the time this case reached that stage, the ground was already unstable. Her husband entered the custody phase with a clear objective, not to remove her from the child's life, but to redefine her role within it. He framed himself as supportive, involved, and patient. He emphasized his willingness to cooperate. He spoke often about balance, structure, and routine. And then, subtly, he began questioning her emotional judgment. This is where custody cases become especially dangerous for mothers, because care is often mistaken for excess and attachment is easily reframed as instability. He raised concerns about her responsiveness. He suggested that she reacted too quickly to distress, that she intervened too often, that she struggled to tolerate discomfort, both her own and the child's. None of these claims accused her of neglect. That would have been too obvious. Instead, they questioned her capacity for moderation. Moderation is a loaded word in family court. It sounds reasonable, objective, balanced, but when applied selectively, it becomes a weapon. He argued that the child needed firmer boundaries, that emotional independence should be encouraged earlier, that her parenting style risked creating dependency. Dependency. That word appeared again and again, not in anger, in reports, in summaries, in carefully chosen phrases. She listened to these arguments with a composure that masked how deeply they cut, because they weren't attacking her actions. They were attacking her instincts. Expert involvement was suggested. Again, this sounded neutral, professional, responsible. Psychological evaluation is often framed as protection for the child, but it also shifts power, because once an expert is introduced, lived experience becomes secondary to interpretation. She agreed. Not because she felt confident, but because refusal would have been framed as resistance. The evaluations were thorough, observations, interviews, questionnaires. She answered honestly. She described routines, explained decisions, spoke about emotional safety. She did not exaggerate, she did not dramatize. She trusted that truth would be enough. Her husband approached the process differently. He focused on presentation. He emphasized calmness, downplayed conflict, highlighted her emotional investment as contrast to his stability. The expert reports that followed were not condemning, they were cautious, and caution is often worse. They acknowledged her dedication, her attentiveness, her consistency. But they raised questions about anxiety, about over-involvement, about resilience. Questions do not need answers to cause damage, they simply need space. The hearings reflected this ambiguity. The court did not accuse her of being unfit, but it questioned whether her parenting style allowed for sufficient independence. This is the tightrope many mothers walk. If they protect, they risk being seen as controlling. If they step back, they risk compromising safety. There is no neutral posture. Throughout this phase, she felt something shift internally. Not fear, anger, not explosive anger, quiet recognition. She realized that she was being asked to justify something fundamental, her right to respond to her child. Her husband's legal team continued emphasizing reasonableness. They suggested incremental changes, trial arrangements, temporary adjustments, each framed as compromise, each designed to test compliance. She accepted some, refused others, each decision was noted. The child, meanwhile, showed signs of stress, subtle ones, changes in sleep, in behavior, in emotional regulation. She documented these carefully, not to dramatize, to protect, but even this documentation was scrutinized. Was she interpreting too much, projecting anxiety, creating problems where none existed? This is where many parents break, because when a system questions your interpretation of your own child, doubt creeps in. She resisted that doubt, not by arguing, by grounding herself in consistency. She kept routines stable, responded predictably, maintained calm, and slowly something became evident. The child responded best to stability, not imposed independence, not forced detachment, stability. That observation began appearing in professional notes. Quietly, without emphasis, but it mattered. The hearings stretched on, each one draining, each one requiring restraint. She learned to speak only when necessary, to answer questions directly, to avoid defending herself emotionally. This discipline protected her, because emotional defense is often misinterpreted as instability. Her husband, meanwhile, struggled to maintain consistency. His narratives shifted slightly depending on context, not dramatically, but noticeably. What he described as concern in one setting appeared as frustration in another. The court noticed, experts noticed. Consistency once again became the deciding factor. By the end of this phase, the tone had changed. The court was no longer questioning whether she loved her child. It was questioning whether the pressure placed on her was justified. That shift was subtle, but decisive. This case had reached a critical threshold. Motherhood had been scrutinized, tested, challenged, and it had endured. What remained now was resolution, not just legal, but personal. Because even when a mother is not punished for choosing her child, the process leaves marks. And those marks do not disappear when the hearing ends. Part 5 complete. When you're ready, say Part 6. Part 6 will move into judicial reasoning, custody determination, the final balancing of rights, and the moment the impossible choice is finally answered, you are now entering the resolution arc of this case. Start 6 part. All right. Here is Part 6, continuing the same lawyer-narrated, serious, emotionally controlled style. This part moves into judicial reasoning, custody determination, and the moment the choice is finally examined by the court. Case, Part 6, Lawyer-narrated, judicial reasoning, custody determination, the false choice exposed. By the time the case reached this stage, the courtroom no longer felt adversarial. It felt evaluative. The chaos that often surrounds custody disputes had settled into something colder and more precise. The court was no longer interested in arguments about intention or perception. It was focused on outcomes. What actually happened to the child? What patterns emerged under pressure? What behaviors remained consistent when control was removed? This is the phase where many parents expect relief. Instead, they encounter the hardest truth of all. That the court is not deciding who is right, it is deciding what is sustainable. The judge began by addressing the framework of the case, not the marriage, not the conflict. The child. The court reviewed timelines carefully. It examined how caregiving responsibilities had been carried before separation, how decisions were made, and how the child responded to change. And something important became clear. The child's emotional stability had never been the problem. The instability had come from conflict around authority. That distinction mattered, because it reframed the entire narrative. This was not a case of a mother struggling to let go. It was a case of a parent responding consistently while another attempted to redefine control. The judge addressed the issue of attachment directly. Attachment, the court noted, is not inherently unhealthy. It becomes problematic only when it restricts development, and there was no evidence of that here. What there was evidence of, however, was distress when caregiving arrangements became unpredictable. That observation carried weight. The court also examined communication patterns, not just what was said, but how it changed over time: early cooperation, gradual pressure, escalation through implication rather than demand. The court recognized this progression. And with that recognition, the false choice at the heart of the case began to unravel. The idea that she had to choose between her child and her marriage was never a legal requirement. It was a psychological construct, one that served control. The judge did not use language like manipulation or coercion. Courts rarely do. Instead, the judge spoke about imbalance, about how one parent's needs had been prioritized over the child's emotional safety, about how requests framed as reasonable had carried disproportionate consequences. The custody determination reflected this understanding. Primary caregiving responsibility was recognized where it had always existed. Stability was prioritized over symmetry. Structure was designed around the child's demonstrated needs, not around adult discomfort. This was not a punishment, it was an alignment. The court acknowledged the father's role. It did not diminish his importance, but it removed leverage. And that distinction is critical because leverage is not the same as involvement. The final custody framework was clear. The child's emotional safety was non-negotiable. Consistency was essential. Parental cooperation could not be forced through pressure. For her, the ruling did not feel triumphant. It felt clarifying, because what the court effectively said was this: you were never wrong to protect your child. You were wrong to be made to believe you had to choose. That realization hit harder than the ruling itself. She had spent months believing she was standing at the center of an impossible decision: marriage or motherhood, love or protection. The court revealed what she had known instinctively all along. A marriage that demands a child be deprioritized is not a marriage asking for balance. It is a marriage demanding surrender. As proceedings concluded, her husband remained composed. But something fundamental had shifted. His arguments no longer defined the space. They were contained within boundaries he did not control. For the first time since the child was born, decisions were no longer filtered through appeasement. They were anchored in need. The court did not celebrate this outcome. Courts rarely do. They recorded it. And in doing so, they removed the burden she had been carrying alone, the idea that she had to justify choosing her child. That burden was now gone. What remained was adjustment, not easy, not immediate, but grounded. As she left the courtroom that day, she was not thinking about her marriage. She was thinking about something far more important. That her child would grow up without learning that love is conditional. And that lesson alone justified everything she had endured. Court rulings create structure. They do not create peace. That distinction became clear almost immediately after the custody decision was finalized. On paper, the case was resolved. The framework was defined. Boundaries were established. But emotional consequences do not end when legal language does. For her, the days following the ruling were disorienting. There was relief, undeniable relief, but it was muted. She had spent so long preparing for loss that stability felt unfamiliar. She found herself waiting for something else to happen. For years, tension had shaped her days. Now that tension was gone, at least legally, her body did not know how to respond. This is something courts never address. Survival creates habits. Those habits do not disappear with validation. Co-parenting began under the new structure. Communication was limited. Exchanges were brief. Language was careful. On the surface, things appeared calmer, but calm does not always mean healthy. Her husband complied with the ruling, not enthusiastically, correctly, and compliance without accountability can still carry resentment. He followed schedules, respected boundaries, avoided overt pressure, but the emotional undertone remained. Silence replaced argument, distance replaced conflict, and that silence carried its own weight. She noticed how careful she still was, how she still monitored her tone, still considered how decisions might be interpreted, still questioned whether asserting boundaries would create consequences. This is the residue of control. Even when authority is removed, its imprint remains. Her child began adjusting slowly. Stability returned in small ways. Sleep improved. Emotional regulation steadied. Transitions became easier. These changes mattered more than any ruling, because they confirmed something she had trusted all along. Protection had never been the problem. The pressure to stop protecting had been, yet the emotional cost lingered. She experienced guilt not because she regretted her choice, but because the process had forced her to justify it. No parent should have to explain why their child's well-being comes first. That explanation leaves scars. She also grieved, not just the marriage, but the version of motherhood she had imagined, one that did not involve scrutiny, one that did not require defense, one that was not framed as excess. That grief surfaced unexpectedly, in quiet moments, in ordinary routines, in the absence of conflict. As a lawyer, I see this often. When people survive prolonged pressure, peace can feel empty before it feels safe. Her support system reacted in mixed ways. Some apologized quietly for not recognizing the pressure earlier. Others reframed the past to align with the outcome, and some avoided the topic entirely. Truth makes people uncomfortable when it challenges their assumptions. She did not push for understanding. She had learned that clarity does not require consensus. Co-parenting remained functional but distant. There were no attempts to renegotiate control, no overt conflict, just a recognition that the dynamic had shifted permanently. The false choice that once defined the relationship no longer existed, and without it, leverage disappeared. For her husband, this meant adjustment. For her, it meant recovery. Recovery did not look dramatic, it looked slow. She began reclaiming routines without fear, making decisions without rehearsing explanations, responding to her child without filtering instinct through doubt. These changes were subtle but powerful. The most significant shift was internal. She no longer questioned whether choosing her child made her unreasonable. That question had been answered definitively, not by opinion but by outcome. Yet the experience left her changed. She became more guarded, more selective, more aware of how language can be used to pressure. This awareness was not bitterness, it was wisdom. By the end of this phase, the case had faded into structure. It existed in schedules, in agreements, in boundaries. But the emotional work continued quietly. She was no longer fighting. She was rebuilding. And rebuilding takes time, especially after a system has asked you to prove what should have been unquestioned. This part of the story is rarely told. Because it does not look like victory, it looks like endurance. And endurance, though quiet, is often the most honest measure of strength. Part 7 complete when you're ready, say Part 8. Part 8 will be the final conclusion. Long-term healing, the lesson of the false choice, and a closing reflection that stays with the audience. You're now one step away from closing this powerful case. Yes, all right. Here is Part 8, final part of the case. This is the closure, written long, reflective, emotionally complete, fully lawyer-narrated, designed to leave a lasting impact on the audience. Case Part 8, final, lawyer-narrated, long-term healing, the truth about the choice. Final reflection. Cases like this do not end with a ruling. They end much later, in the quiet moments when a parent realizes they are no longer living in defense mode. Months after the custody decision, her life did not suddenly become easy, but it became honest. There were no more ultimatums. No more conditional love, no more subtle warnings disguised as concern. What remained was responsibility, shared, defined, and bounded. For her child, the change was gradual but undeniable. Security returned not because everything was perfect, but because it was predictable. The child no longer sensed tension in every transition. Emotional responses were no longer treated as problems to be corrected. The environment stabilized, and stability for a child is more powerful than any legal victory. For her, healing unfolded quietly. She stopped explaining herself, stopped justifying her instincts, stopped preparing for arguments that never came. The most profound change was internal. She no longer questioned whether choosing her child had been selfish. That doubt, the one planted by years of pressure, finally lost its grip. She began to understand something crucial. The choice she was forced to make was never real. It was manufactured. No healthy marriage asks a parent to compete with their child. No loving partnership frames protection as betrayal. No balanced relationship demands loyalty at the expense of safety. That realization reframed everything. She didn't lose a marriage. She escaped a dynamic that required her to abandon herself and her child to survive. Co-parenting continued. Not warmly, not bitterly, correctly. Boundaries were respected because they were enforced by structure, not negotiation. There was no longer room for emotional leverage. That loss of leverage mattered more than the outcome itself, because leverage is what had sustained control. Without it, the relationship reset into something smaller but safer. As a lawyer, I often see people assume that justice looks like punishment. It doesn't. Justice often looks like limitation. Limiting the power someone has to harm, limiting the reach of manipulation, limiting the space where fear operates. That is what happened here. Her husband was not condemned, but he was constrained. And for someone who relied on emotional authority, that constraint was decisive. For her, the long-term work was about trust, trusting her judgment again, trusting her instincts, trusting that love does not require self-erasure. She rebuilt her life around those principles. Slowly, deliberately, without apology. This case stayed with me because it illustrates something the legal system rarely says out loud. Parents should never be forced to choose between love and protection. When that choice is presented, it is not a dilemma. It is a warning. To anyone listening who recognizes pieces of themselves in this story, understand this. If someone asks you to choose between your child and your relationship, the relationship has already chosen itself. Protecting your child is not defiance. It is not excess. It is not instability. It is responsibility. And responsibility does not need permission. This case did not end with revenge. It did not end with triumph. It ended with clarity. And sometimes clarity is the most powerful form of freedom there is. Case closed. Thank you for staying until the end. If this story resonated with you, remember, a choice that costs a child's safety is never a real choice. And no one should have to learn that the hard way.